another episode of Ask Jade. So today I'm going to talk about what is a cease and desist letter or email or any type of correspondence. So you're going about your business and you're like, oh, I received a letter that says to cease and desist. What do I do? So let's start. What is it? A cease and desist or demand letter, or it might come in the form of email as well. It's correspondence that suggests that you are potentially infringing, usually on a trademark or a copyright of another, and they demand that you stop using it. And they, might make a demand for payment as well. You should treat this seriously, take it seriously, read it, pay attention if there's deadlines in it. What are your options? One, you can respond. If you have a basis for doing so, you can respond to it, deny the infringement. You can respond and request more specific information as to why they believe that you're infringing on the mark, the date, proof that they actually have a mark, geographic areas, all of that type of information. Another option, do nothing. So you can elect to not respond. Some of these are sent out in the hope that you're going to be misled or intimidated to stop doing something that you're not even really doing. So it's always best to consult an attorney, such as myself. Another option, negotiate. So you can negotiate with the owner of the trademark for a license to use the mark. That's an option. That's on some sort of agreeable terms that you both agree on. Or some other type of kind of mutual settlement agreement and negotiate with them. Another option, file your own lawsuit. You may want to explore suing this supposed or alleged owner for something called a declaratory judgment, stating that you're not infringing on their mark. So an attorney experienced in this, such as myself, would be best to consult and pick what option might be best for you. So does this mean you got this letter, you got the cease and desist? Are you getting sued? Does it mean you're going to be sued? Receiving the letter without more does not mean you've been sued. So if a suit has actually been filed against you, they must serve you a complaint and a summons. So the letter alone is not a suit. Now, what if they say they're claiming that you're infringing on this mark and it's not actually federally registered, or that it's expired or it's canceled? So federal registration alone does not establish trademark rights. So even if it's expired or canceled, there might be common law rights to that mark. And same goes for you and your business. So common law rights, they arise from just actually using your mark, your logo, your name, in conjunction with your goods or services in commerce. So it's good to be using it, but then obviously you need that protection of the filing as well. So do you need an attorney? Now, while you're not required to get an attorney if you just get some sort of cease and desist letter, an attorney can obviously help you understand the scope of your own rights, the strengths and weaknesses of these allegations against you, and advise you on what might be the best option. So there's several different ways to go about this. At the end of the day, it is always best to at least have an attorney take a look at it and advise you on what the best options might be. As always, feel free to reach out to myself, Jade Carpenter at Zeidman & Carpenter, and I'll see you next time.